Emma Mijas died a horrible and painful death unnecessarily on her very first Christmas Eve 2004 at the hands of 25 doctors and nurses, another victim of medical malpractice. All 25 doctors and nurses systematically administered the wrong drugs for her life-threatening condition called SLOS. SLOS, Smith-Lemli-Optis syndrome, is a congenital abnormality which requires treatment strategies on supplying supplemental cholesterol. They gave Emma the wrong drug, Questran, not once, but 92 times. Yes, 92 times in 1 month. A cholesterol-reducing drug, not the cholesterol supplemental drug she needed. All of them knew better. They were trained to know better. They were some of the world's leading authorities at the Louisiana State University Health Science Center in New Orleans. But they just didn't give a damn about Emma's life. In 2013, the prestigious Journal of Patient Safety published a study that as many as 440,000 patients die each year from preventable medical errors. That would make medical errors the third leading cause of death in America, behind heart disease and cancer, which is second. These people are not dying from the illnesses that caused them to seek hospital care in the first place. No, they are dying from mistakes that hospitals could have prevented. What are these fatal errors? Who are these incompetent and negligent doctors? A New England Journal of Medicine, January 28, 2016 study reported that 1% of physicians accounted for 32% of paid malpractice claims over the last 10 years. The ugly truth is that little is being done to hold these dangerous doctors accountable. Researchers found that bad doctors showed distinctive characteristics, including having paid previous malpractice claims. So it stands to reason that healthcare providers could eliminate 1/3 of medical malpractice along with patients' pain and suffering, as well as the added cost of corrective surgeries, long-term care, and indemnity payments by removing the worst 1% of doctors. Why aren't bad doctors stopped from practicing? The answer lies, at least partially, in the National Practitioner Data Bank, a clearinghouse for information on medical malpractice that Congress established in 1986 to help state licensing boards police the healthcare industry. The national database was supposed to help states identify dangerous doctors and prevent them from harming more patients, and is used by hospitals, insurers, and licensing boards to track doctors' records, check prospective hires, and make other decisions. But it is virtually useless in holding doctors accountable because, by federal law, none are listed by name. They are assigned a random number to protect their identities. Even if doctors were identified in the data as they should be, the public would still be barred by law from accessing the records. So vulnerable, sick patients sit in the waiting rooms of bad physicians without a clue about their poor record of performance. And in many cases, a negligent doctor's insurance company pays the victim of malpractice and the doctor goes back to work. If a doctor develops a bad enough reputation in one town, he can move to a new state and continue practicing. This is unbelievable. But today, the public does not have access to the database to identify doctors' names and addresses, to identify doctors with uniquely long histories of being sued or disciplined for medical malpractice. Because on September 1st, 2011, the government cut off public access. What was behind that decision? Apparently, one Kansas doctor with a trail of malpractice suits, Dr. Robert Tenney. The Kansas-based doctor complained to the Government Health Resources and Service Administration that the Kansas City Star newspaper was publishing the story of one of his patients, Mary Beth Chase, who died in 2007 after undergoing a brain surgery with Dr. Tenney. It is also noted that Tenney has been sued at least 16 times for medical malpractice, but had never been disciplined by the state's licensing boards. The Insider Exclusive produced a TV story on this case with the lawyers who represented Mary Beth's family when doctors go bad, Mary Beth Chase versus Dr. Robert T. Tenney. Tenney finally settled the Chase family's wrongful death suit for $1 million. The settlement brought total malpractice payments paid on Tenney's behalf since the early 1990s to roughly $3.7 million. In some states, including California, Colorado, Georgia, and New York, patients can go to medical boards' websites to find out about doctors' malpractice histories, but not in Kansas and Missouri. Why don't doctors report on bad doctors? Physicians often see the mistakes made by their peers, which puts them in a sticky ethical situation. Should they tell the patient about a mistake made by a different doctor? Too often they don't. Why not? One reason is that doctors depend on each other for business, so a physician who breaks the code of silence may become known as an informer or snitch and lose referrals, a financial penalty. Doctors also may be wary of becoming entangled in a medical malpractice case or causing a colleague to face legal consequences. The bottom line, too often doctors aren't learning from errors, nor are patients getting the information they need to receive proper treatment or compensation when the outcome is harmful. In this Insider Exclusive Network TV special, America's Medical Malpractice Crisis, What You Need to Know, we visit with John Hammons at Nelson and Hammons Law Firm as we take you inside today's legal system, examining lawyers' strategies and clients' thoughts, and in vivid detail showing you the often heartbreaking stories of these clients, dramatically demonstrating what motivates John to fight for his clients' causes. These victims could be you or me one day, and if you are so unlucky, you will quickly find out that justice in America is a hard-won battle where very few insurance companies, doctors, nurses, or hospitals ever do the right thing, and you need experienced and passionate trial lawyers who wage a battle with their financial resources to get their clients justice. Here's just a few of the stories of many victims of medical malpractice that the Insider Exclusive Network TV shows have featured on Network TV.
When the doctors gave me the choice and the options on the table, either to save her life or to let her pass and peacefully without no pain, it was a small chance that she might live after surgery. But I chose life because I think that anybody deserves a fighting chance. So I decided, my wife and I decided to go ahead with the surgery and give her the chance to fight herself. My daughter Malia is special because she has a positive outlook on life in general, on how well she can accomplish things, how she's not different in any other way from anybody else besides the fact that her legs are metal. When I realized that this could have been possibly avoided by doctors seeing my daughter sooner, of course I was very angry. But I was also focusing on my daughter's condition at the present time. But it also made me think a lot about myself if I would have, demanded her to get attention sooner. I mean, there shouldn't be these things where we have to look back on it now and say, I wish I could have done this different. I wish I would have done this. Well, my daughter doesn't get that choice anymore. She has to live with this for the rest of her life. So hopefully this would be a learning experience for the doctors. That's why I would forgive them and tell them that, Amy, just get better at what you do, or pay more attention.
She was a tremendous life, unbelievable energy. She threw parties and she had people over, and she always made dinners for anybody who was sick, and she got involved in every campfire girl, Boy Scout.
She was very capable, smart, giving, dedicated to her children, dedicated to me.
And I kept saying, Mom, what's wrong? What hurts? And she says, my abdomen. And she kept and she was miserable. And we said, well, please call a doctor. She needs to be examined. We asked him 3 times.
The nurse said they'd call the doctors. The doctors were aware of the problem, but the unfortunate part about it is the doctors never showed up.
And that's when I reached down and hugged her and I said, we're here. And she opened her eyes.
When the doctors told me that I had to make a decision for my husband's amputations to survive or just let him go, that was very difficult for me. I had to think about it and pray about it and talk with my family. It was a hard decision and life-changing.
My wife has been an angel. She's stuck by me. She's done everything for me. My mom, my sisters, my brothers, my kids. Without them, I wouldn't have made it.
Dr. William J. Irwin failed to comply with the appropriate standard of care for an OB/GYN in the year 2007. And as a result, Rebecca Gatti, a newborn baby, suffered severe brain damage which is lifelong and irreversible. Those brutally frank words were how the Louisiana Medical Review Board explained to Ryan and Susan Gatti, the parents of their new baby girl Rebecca, why Rebecca had suffered irreversible brain damage due to the incompetence of Dr. Irwin, and now will require round-the-clock care for the rest of her life with no chance whatsoever for improvement.
Well, on the day that I gave birth to the boys, I was very scared. You know, it's first time you're getting all ready to your life to change. In the delivery room, they would monitor me and they had all this equipment on me, and then all of a sudden, when he pushed down on my stomach, when the placenta blew away from the uterus, I let out this really loud scream, and it was very painful. And then I just looked at my sister and I knew something was really wrong. I first realized something was wrong with Hunter. Well, he was in the NICU for a week, 8 days. And when he got released, they had told me that Hunter was going to have learning disabilities and he might be dyslexic, but they never mentioned that he may have cerebral palsy. If I had a chance to talk to the doctor today or directly to him, I would say, how dare you? How dare you take away the life that I was supposed to have? And how dare you do this to Joshua?
What I miss most about my mom are the holidays. The house was transformed. My biggest challenge with my mom gone is trying to step in her footsteps. Doctors who are not qualified to perform certain procedures, their license should be revoked. Dr. Jacobowitz, I don't have words. I don't have the words to express what your actions has done, the pain and the suffering that it has caused that can never be reversed.
These are just a few of the real medical malpractice victims who have dealt with our legal system victimized by bad doctors. This is why we all need to protect a legal system that is designed to protect us. and not one that protects incompetent and negligent doctors, nurses, hospitals, and their insurance companies over the common everyday American. John Hammons, our featured lawyer, has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Shreveport and Louisiana. He has seen many innocent and hardworking people injured and killed by negligent and incompetent doctors, hospitals, and nurses. John's passion is problem solving. He approaches each case as a scientist trying to solve a puzzle. He has seen many patients suffer needless injury. And because of that, he is driven to help people who have been harmed by incompetent and negligent doctors. John's goals: to get justice and fairness for injured people, safeguard victims' rights, and to help guide the hands of justice. As he has so often stated, medical malpractice is also becoming a deserted wasteland for trial lawyers due to expense caps, manipulation of the system, judicial influence, and the insurance industry's orders to its insured physicians not to participate or cooperate. This is the Insider Exclusive, live from Shreveport, Louisiana. It is my great pleasure, once again, to introduce John Hammons of the law firm of Nelson Hammons. Welcome to the show, John.
Thank you very much. Glad to be here.
It's been a number of years.
Has been.
And we're here today to talk about the problems with medical malpractice, the myths that people have, and the truths of medical malpractice. But I remember many years ago when I first met you and interviewed you on a number of very amazing cases that you handled, that when I asked you, why do you do what you do? I remember you said, and no other lawyer has ever said this to me, I do this, Steve, because I think it's my mission in life.
It's true.
You still believe that?
Absolutely. I consider what I do to be a calling, and I truly believe that I'm doing what God called me to do.
Yeah.
And as a result, it's not work.
Yeah.
It's a mission.
Yeah.
It truly is.
Well, today we're here today to talk about the truths and myths of medical malpractice. There's a lot of people believe, and I'll start this right off before we even define what medical malpractice is. A lot of misinformed people believe that there should be some kind of restraints on the amount of money that a person who has been harmed by a doctor or a healthcare professional should get. Because there are trial lawyers behind this whole thing that are trying to file any suit that they possibly can, which is defined as a frivolous lawsuit, because they want to make a lot of money, not only for them and for their clients. What do you have to say about this?
Well, first of all, the concept of frivolous lawsuits in the arena of medical malpractice is a myth. The obligation, certainly in Louisiana, for what we have to do in order to win a case requires a lot of money, a lot of time, and therefore it doesn't pay to file a claim that is not meritorious, that you have not already done the work to do. So we really don't see, and I really do, there are people that file claims that are not meritorious. But that's a far cry from filing a claim that is frivolous.
You have been a lawyer for many years.
Over 40.
And for our audience, as you mentioned, frivolous means kind of worthless.
That's correct.
Generally, what I've seen, and I have reported on hundreds of cases, what I've seen is when lawyers file worthless lawsuits, frivolous lawsuits, they are dismissed, they're thrown out of court, they never make it past the entrance gate. And if a lawyer continues to behave this way, generally a judge will recommend that he be disciplined by the bar. Is that right?
Either a judge or other lawyers or the disciplinary counsel, which we have in Louisiana.
Yeah.
You really don't see a frivolous claim in the arena of medical malpractice in Louisiana never even gets to court.
Yes.
Because you cannot even file,
right.
You cannot even get in the courtroom unless you have physicians willing to testify that the defendant healthcare provider committed medical malpractice.
Right.
So almost by definition, we do not have frivolous lawsuits in the arena of medical malpractice in this state.
And you brought up another point, which is, in these types of cases, most of these clients that come to you, they're almost penniless. They don't have money to hire a lawyer. So thank God there are lawyers like yourself, plaintiff lawyers, real trial lawyers, not litigators, trial lawyers, who, when they evaluate a case, will say, okay, I think this is a worthwhile situation that I should pursue. And in doing so, a typical medical malpractice lawsuit costs a lot of money, doesn't it?
Oh, it costs. To try in this state, with our limited recovery, which is different from other states, but and I'm sure we'll speak about that. But we still routinely will spend $40,000 to $60,000 taking a case to trial.
And that includes not only the lawyer's time doing the research. You don't work for free. You can't afford to.
Well, we actually do work for free if we lose.
Yeah, but I mean,
the bottom line is we spend an enormous amount of time because of the very nature of what our practice is, what is required to learn the medicine, and then the requirement to have expert witnesses, meaning physicians, requires a substantial outlay of money.
Because what does a typical expert cost? They cost for their opinion. That's one cost, right? And if they have to be deposed, that's another cost, right?
That's correct.
And that's their time too. So what are we talking about generally?
Typically, if I retain an expert to assist me in evaluating a case on the front end, that cost will be $2,500 to $4,000.
Okay.
Then if that expert is deposed, which you most certainly will be, we can expect another $2,500 to $5,000 for the deposition. And then if that witness has to come to trial, because many of those witnesses are from out of state, now we're going to spend another $10,000 to $15,000.
Yeah.
So one witness can easily cost as much as $25,000 for just one witness. And most malpractice cases require more than one expert witness to carry your burden of proof.
And the reason for that is because the other side will generally they'll generally supply multiple witnesses too, won't they?
That's correct. They have access to far, far more.
So if we get to trial, your experts are called, we're looking $50,000 for two experts, aren't we?
Easily.
And those doctors are going to be paid, regardless of whether you win or lose.
That's correct.
Which should send a message to everybody listening to this and watching this show that a lawyer would have to be insane to file a frivolous lawsuit and pay doctors to try to win a case that has no merit, right?
It's absolutely true.
So let's talk about, we all know the movie The Verdict with Paul Newman.
Yes.
It was a medical malpractice case. And a lot of these cases come down to the battle of the experts.
They all do.
Yeah. How does a jury, in your evaluation, look at these experts? One side is saying this guy's graduated from Yale and Harvard, and he's been on the staff at this prestigious hospital for 20 million years. That's all fine and dandy. Doesn't mean he's a good doctor, right?
That is correct.
How do you convince a jury that your experts are better?
It's one of the most difficult aspects of malpractice litigation because you cannot necessarily correlate one's ability to communicate in the courtroom with his medical ability in his office or the hospital.
He could be a stoic kind of a person.
Very much so. Many doctors And many doctors are by nature not very good communicators.
Right.
That's not their strong point.
Right.
And so the real key is, in my estimation, is to build a case that is simple. The KISS principle, keep it simple, stupid. Because jurors have a difficult time dealing with complex medical issues. And the typical defense approach is to make the case as complex as they can make it, to sort of wow the jury into saying, oh, well, if anything is that difficult and that hard, we can't possibly hold them.
In the courtroom, you tear that apart, don't you?
You attempt to do so, and
now,
to make it simple.
Let's talk about experts. You know, you're a very well-respected medical malpractice doctor in Louisiana.
Or lawyer.
I mean, excuse me, lawyer in Louisiana.
Although some laughingly
but you know enough about medicine, you might be a doctor too. But you run into the problem all the time about experts who don't want to testify because they're retaliated against by their associations. Isn't that right?
That happens. Probably there's a reluctance, particularly in this state. There is a significant reluctance on the part of many physicians to hold their peers accountable. And that is one of the problems. We have, as I think you know, a medical review panel process that you may want to get to at some point. But before our cases ever make it to the courtroom, we have to have those cases evaluated by a panel of 3 physicians of the same specialty as the defendant, which means their own colleagues, people they go to school with, people they work with,
people they know,
people they socialize with, are the ones that are going to tell the jury whether the defendant did something right or wrong.
My friend, the one I go to dinner with, you know, at least once a month, our wives know each other well, I'm going to say that he's not. He's screwed up.
Yes. A quick statistic that will help.
I know what this is going to be. But go
ahead. The medical review panel process in Louisiana since 1975 has resulted in judgments or, excuse me, opinions favorable to the doctor 92% of the time. So claimants only win at the panel stage about 8% of the time.
Okay, well, let's talk about this. You are required, are you not required in the state of Louisiana to put your case first before the Louisiana Medical Board?
That's right.
You can't file a lawsuit, a medical malpractice lawsuit, without having them review it first?
That's correct.
Okay, so how long do they get back to you? That's another interesting.
The panel process statutorily was designed to be completed in a year. As a practical matter, never less than 2 years, oftentimes 3 years.
So wait a minute, somebody comes to you, their mother, their father, their brother, their son, their daughter dies. They're upset. You say, I'll take your case. You work the case up, you send it to the medical review board. They don't get back to you for 2-3 years?
That's correct.
And
routinely.
And you can't go to court at all.
Cannot do anything until the panel renders its opinion. So I generally
this must make everybody so irate.
It's very difficult. It's one of the intentional portions. It was intended when the act was passed as one of the means of chilling the efforts on the part of injured patients or their families in pursuing a claim. And certainly lawyers.
Because there's no, you know, if you were to win, to put this in common, you know, lingo terms here, there's no payday for a long time. Not only for your client, but for the lawyer.
Well, I've just written a paper that's designed for young lawyers and inexperienced lawyers to express to them the problem pragmatically for a young lawyer who undertakes a case and may have to advance $25,000 or $30,000 on a malpractice claim with no chance of recovery or reimbursement as a practical matter for anywhere from 5 to 7 years. And that's only one case.
So let's get back to this 92% in favor of the doctors. Most of them are unfavorable reviews.
That's correct.
And so their language generally says this, what? We find that the doctor did not commit medical malpractice.
That's correct.
So then you take that for most of your cases, right?
Mm-hmm.
You take that, that's going to come out in the trial.
Not only does it come out,
yeah,
that is written. It's in a written document.
Yeah.
The defense will blow it up as big as the wall
yeah.
and parade it around. And they will tell
yeah.
the jury 3 doctors who have devoted their lives to the people of this state
yeah.
have already reviewed
yeah.
this case before Mr. Hammons
yeah.
could ever even file a lawsuit.
Yeah.
And they unanimously told him that there was nothing wrong. And he went ahead and filed this frivolous lawsuit anyway.
Yeah.
Now that's the way it's presented. And let me mention one other thing, because this is
this is like starting with not only your arms tied behind you.
The table is never. We never have a level playing field. And what makes this even worse is that the panel opinion in its written form will accompany the jury to deliberations. But that is the only evidence in the way of testimony from an expert that goes back into the jury deliberation room.
Right.
So this panel opinion, which almost always is adverse to the patient, is going to accompany the jury. And if there are questions, the only thing they have to look at is the panel opinion.
And their notes that they took of the
and their
experts.
notes. And so that's what we're dealing with.
Let's talk about, going back to the movie The Verdict. Paul Newman could not find the one expert that he wanted disappeared. So he found another expert who had testified multiple times. In fact, he had probably given up the practice of practicing medicine, right?
To be an expert.
To be an expert. How do you deal with that?
Well,
how many times can you use a doctor? Because you've done this for 40 years. How many times can you use the same doctor in case after case after case without him losing his effectiveness?
Fewer times than many people think.
Yeah.
The reality is that is a big issue that is frequently every lawyer on both sides of the fence look into that issue to find out how many times witnesses have testified. But let me add one other thing. The reality is that it is a challenge for a physician to come forward and to honestly and forthrightly proclaim that one of his peers did something wrong. No matter what the facts are. And therefore, there are many, many doctors who will tell me privately, yes, this is malpractice, but if you call me, I will not say that under oath. So on the plaintiff's side, the group of physicians available to us is minuscule compared to the group of experts that are prepared to protect the doctor at any cost.
Do you often have to get doctors out of this jurisdiction, out of Louisiana?
All the time.
All the time.
98% of the time.
Yeah. So then, of course, I can see the defense attorneys saying, yeah, they got this, big city doctor from New York City, right?
That's correct. The usual argument to the jury is Mr. Hammons could not find a single doctor in the state of Louisiana.
Are you allowed to address that? The reason I couldn't find
and I do. And I do. Okay. And so that's the give and take.
Yeah. And it's amazing. This is what's amazing. And we're going to get into this now, about the caps you have in Louisiana, all for a maximum recovery of $500,000.
That's correct.
And I'm going to say that louder, $500,000. Now, let's talk about, we've talked around the issue. What is medical malpractice? What is it in simple terms so people can understand it? Because I know you can say, it's below the standard of reasonable care. That doesn't mean anything to anybody. What's that mean?
What it simply means is, has a doctor done something he should not have done? or has he failed to do something he should have done?
Yeah.
It's really simple.
Does it have to be real blatant?
No, it does not.
Okay.
Does not.
Okay.
Malpractice, medical malpractice, and the term malpractice was actually coined by the medical and insurance industry in order to make people think what you just said, that in order for a doctor or a hospital to be held accountable, they have to do something outrageous,
right,
something offensive.
Yeah.
That's not it at all.
Yeah.
It is simple carelessness.
Mm-hmm.
That's all that malpractice is. Failing to pay attention to what a patient tells them,
right,
failing to look at an x-ray properly,
yes,
failure to follow up, failure to know things you should know.
Right.
And if those omissions occur and cause harm, then that is a meritorious claim.
Right.
By law.
Yeah. I'm just curious, how many medical malpractice cases do you take on a year?
On the well, let me say, I receive on the average about 110 new client calls a month.
A month.
I review those, and I generally, so that's 1,200 to 1,500 cases a year that I investigate.
Right.
And then I generally have a continuing active practice of about 200 active files at any one time.
Per year.
So I may open 20 new cases and settle 20 cases in the same year.
We reported on one of your cases, Sharon Boxey.
Yes.
Lovely person. Terrible thing happened to her. She was awarded a $5 million verdict for pain and suffering, if I remember correctly.
That's correct.
And the judge reduced it per the law in this state down to $500,000.
That's correct.
Okay. She is a quadriplegic.
That's correct.
I think she was 38 when she was
also
rendered
correct.
Quadriplegic. She has probably 30 good years of living ahead of her. The life care plan, not going to Cedars and Sinai in Beverly Hills, but just a reasonable life care plan is in the millions of dollars to take care of her, correct?
Sure.
Okay.
Anyone that has that kind, and let me mention, because when you say the 500,000, because this needs to be understood, in our state, the 500,000 is not only for pain and suffering, disability, disfigurement, but it also includes any lost wages or lost earning capacity.
Yes.
So I have had multiple clients who were wage earners. So if you have a 40-year-old man with a wife and 3 children, and he's making $75,000 a year, and a doctor renders him a quadriplegic, what are his wage loss?
Right.
$75,000 a year for at least 20 or 25 years.
Yes.
And still, the maximum recovery
is included in that 500,000.
Is included in the 500, and the client has to pay all of the attorney's fees and cost of the litigation out of the 500,000. So the recovery to the client is substantially reduced by virtue of the cost of the litigation itself.
So let's get back to the medical costs, like Sharon Boxey, quadriplegic, millions of dollars. She gets medical care.
She gets medical care.
Who pays for that?
The medical care in Louisiana is paid by the Louisiana Patients Compensation Fund.
Okay. And who pays? Where do they get their money?
That money, it is private money. This Louisiana Patients Compensation Fund is a statutorily created trust.
Yes.
And when hospitals or any healthcare provider wants the benefits of the act, they pay a premium for the first $100,000 of coverage with an insurance company.
Is this medical malpractice insurance?
Yes.
Okay.
And it's only for $100,000. That's all that a doctor ever has to pay, no matter what he does.
Premium on $100,000.
Is premium, and his maximum legal exposure is $100,000.
Right.
The Patients Compensation Fund will charge a corresponding surcharge, and that goes into a fund, and the PCF is the term we use in short, now has about $800–900 million in reserve that is used to pay the $400,000, the difference there, plus to pay at a workers' comp rate the medical bills that the patient incurs. So many of the people, yes, they may be entitled to their medical bills to be paid through this governmental agency, but frequently, because they pay on such a low rate, oftentimes the patients cannot receive care at a premium level. They get second-rate care.
So, in other words, the fund approves the amount of money that is going to be paid a doctor who is treating this quadriplegic.
That's correct.
So if a doctor is charging, for lack of a better example, let's say $5,000 for a operation or whatever it might be, and the fund will come back and say, we're only going to pay $3,000, then that doctor may back out of the...
He might. He may well say...
Is there an appeal process in this kind of situation?
Not for the actual payment, because the PCF has a pay scale that they've approved under Louisiana law. There is an appeal if the PCF refuses to pay. So one of the other... At times there are where they just say, we don't think that has anything to do with the malpractice, we're not going to pay. Then the patient can go back into court and ask the court to order the PCF to pay the bill. But even if you win, you're paid on the scale that the PCF has.
But I'd be worried that if, like Sharon Boxey, she needs medical treatment for something right now, and now you have to wait longer, and she might deteriorate even more.
It's a continuum because the bills are not due until they're actually incurred. So the PCF's obligation to pay does not even arise under the law until the medical care is rendered and the bill issued.
Okay. What do you have to say to our audience about how someone should suspect that they might be the victim of medical malpractice? And let me qualify that. Let me add a little preface to that. Oftentimes, sometimes, a doctor will come out to a family that's waiting for their loved one who's just been in surgery and will say, I have some bad news for you. Despite our valiant efforts, your father, your mother, your son, your daughter died on the operating table. We are real sorry. We did everything possible. And they do say these things. Or despite our valiant efforts, unfortunately, something went awry. These things happen, in medical surgeries. And your son, your daughter, your mother, your father was a quadriplegic, or we cut the wrong leg off. Oftentimes, that family believes the doctor. But you and I are aware enough that doctors are human beings. They make mistakes. Sometimes they're incompetent. Sometimes they're negligent. Sometimes they lie. So in all those cases, because you never know what might be the truth, you should investigate it. How does a layperson, how would I what would I do next to say, I don't believe Dr. Schmidt. I don't believe something's funny happening here, What do I do next?
Let me start that answer by explaining a couple of statistics that are important to the public in understanding their relationship and the obligations of the healthcare industry. The medical community itself, with its own studies, has confirmed that over 400,000 patients a year are killed by negligent and careless medical care. If 400,000 are killed, you can estimate 10 times that many are injured. So we're dealing with between 4 and 5 million Americans are injured or die every year because of malpractice.
And when we say malpractice, we say by
careless medical
careless mistakes by doctors.
That's correct.
Okay.
So we're looking at an epidemic, a tremendous epidemic. So what I share with anyone is, number one, you need to be an advocate for your own medical care. You need to know, you need to ask questions. If you have any doubts as things go along, ask the questions, find out, get second opinions. Common sense, medicine is much more common sense than many people think. And if an outcome, if you go in to have surgery on your wrist and you come out with a paralyzed right leg, actual case I'm handling,
right.
Then that ought to send a message that, wait a minute, this doesn't add up. So in the event that anyone has issues, questions, doubts about why a complication, a bad result, or even a tragic outcome occurred, the first thing they should do is demand an inquiry. Demand that the doctors and the healthcare providers meet with them and talk to them.
But, okay, and we're going to get to records too.
And
I understand.
And then secondly, if they believe that, they need to consult a qualified attorney to help them with their decision making.
Because individually, if my brother or my mother, my wife, my father dies, I can't get their records, can I?
No, well, you can. Well, you can if they die. If you're the,
or if they are rendered quadriplegic.
Yeah, you can get the records if you're the nearest kin.
You can, but it takes a long time.
It takes a while to get them, and the records are oftentimes incomplete or inaccurate, even if you get them.
And sometimes intentionally inaccurate. Correct.
Certainly, absolutely.
So, come to a lawyer. And you now are going to evaluate a case.
Yes.
You can't evaluate a case till you get all the records, correct?
Not thoroughly. There's some things many things, because I've done this long enough, people can share with me. And I know that certain complications are indeed occur even in the hands of the best doctor.
Yes.
But many of the complaints I get require, number one, a detailed interview with the client and the client's family, and then secondly, obtaining the medical records, reviewing those records thoroughly, and getting independent expert opinions, be it nursing, multiple medical specialists, or whatever, in order to try to figure out what happened.
Yes.
And remember, this is a really important aspect and a parallel that I want to draw. If you're injured in a car wreck, the first thing that happens is that an independent third party, a police officer, comes to the scene. They take pictures, they take measurements, they take statements, they write up a police report. So there's an analysis made by an outside third party.
Yes.
In a medical malpractice case, the most important evidence is the medical record. But guess what? That record is generally created by the defendant, interpreted by the defendant, and kept in the custody of the defendant. There is no third-party outside source to evaluate the content and accuracy of those medical records. So you have to get detailed analysis to try to figure out, are these records really accurate?
Right.
Are they complete? And unfortunately, oftentimes they're not.
Right.
You know,
one of the big pitches of the insurance company on getting caps for medical malpractice cases, or for any cases, the whole pitch of tort reform, right, is to keep insurance premiums down.
Absolutely false.
Yeah. In the state of Louisiana, did medical malpractice insurance premiums for doctors go up or down after they passed tort reform in 1975?
They continued to rise.
Okay, now doctors were sold this idea, right?
And the legislature was sold the idea as well.
It has been 42 years since this was passed in 1975.
That's correct.
So, if anybody had a brain, they would see that this wasn't this result did not happen as they intended. correct?
That's correct. And
So
one other
why-
thing.
So go ahead, I'm sorry.
One other thing that you need to understand about this is there have also been any number of studies by Harvard, University of Texas, and several others that have concluded that the entire cost of the medical malpractice system, litigation costs, lawyer fees, judgments, interest, the entire cost represents less than 1% of the total cost of medical care. So the medical malpractice system in this country has little to do, has virtually nothing to do as a practical matter with the cost of health care or the cost of the insurance premiums.
Yeah.
Some of the most profitable insurance companies in America are the companies that insure doctors and hospitals.
Right.
That's simple.
Now, when we talk about medical malpractice, we're talking about, for the most part, most doctors really try hard. They're good doctors.
Absolutely.
Thank God they're around.
Absolutely.
Even though you're suing a number of doctors, they are doctors that have shown that they were incompetent once, twice, many times, multiple times, whatever, or negligent, whatever, and they don't want to own up to it, okay? So how do we get rid of these bad doctors? What is the problem? Because let me give you an example. I did a medical malpractice story in Kansas, the state of Kansas. There was a doctor there by the name of Dr. Robert Tenney, T-E-N-N-Y. Dr. Robert Tenney, he was a surgeon. He had been sued 18 times for either causing the deaths or resulting in severe injury to patients that were in his operating room. 18 times. Complaints flew into the Kansas Medical Board for Physicians, which, by the way, is called the Kansas Board of Healing Arts. Don't ask me how they got this name. It sounds like a dance to me.
Interesting.
But after we did our story, and it was broadcast on 300 network affiliates, the Medical Review Board finally suspended his license. Now, that's all fine and dandy, okay? But he was also licensed to practice medicine in Minnesota and I think Wisconsin. There were two other states. I'm not positive about the two states. So he could easily go over there, okay, and practice medicine. I think statistically that maybe it's in the single digits, 3, 4, 5% of doctors cause 33% of the medical malpractice claims. Is that about right?
I would say so. You know, certainly in my practice, I can share with you that there are in certain specialties physicians that I hold in extremely high esteem who've practiced for 30 or 40 years. I've never received a single complaint, much less a meritorious claim. Nobody's even called. While there may be other physicians in the same specialty where I may get a half a dozen complaints a month. Now that's anecdotal, but it tells me a lot.
It would appear to be a simple solution for the insurance companies just to say, get rid of this doctor. He's costing us too much headaches and money. Get rid of him. Why isn't that happening?
Well, twofold. Number one, the medical community is a club. And even the physicians who are extremely dedicated, extremely competent, there's a great deal of internal pressure on them not to step up to the table, to not be advocates for disciplining their peers.
But this appears to be a little hypocritical, and let me tell you why. These dedicated doctors, the great majority of them, have one mission in life, and that is to do the best care, provide the best care they can for people who need it medically, right? So if you have a peer who's not following that Hippocratic oath, right, then it would seem to me rather simple. Forget about the brotherhood. Get rid of this guy that's not living up to the philosophy that is the reason they became a doctor in the first place, right?
Should be. It's not. And a good example, I tried a case within the last year with a medical review panel where when we went to trial, the panel doctors, I caught them, and the panel doctors admitted that they had falsified their findings at the medical review panel stage in order to protect the defendant.
Did they admit this verbally to
Yes,
you?
to the jury.
To the jury?
And we're proud of it.
Well, how can you be proud of this?
It's a good question for me, and it's something that I have asked the courts, and I will tell you, that I posed to the court, that under our law, the doctors on a panel are obligated. They sign an oath. First of all, there's a statutory duty to be objective, truthful, and honest, and they sign an oath that they've done that. So when a physician, when we're able to prove that that oath, that duty has been violated, in my opinion, those witnesses, whether they're doctors, lawyers, or Indian chiefs, should be held in contempt because they have violated a fundamental duty of fairness owed to the public and to our legal system.
Absolutely.
So we have...
What happened as a result of that? Nothing.
Well, at this point, that's still pending. I've asked the courts to hold those 3 doctors in contempt of court for knowingly filing an
Why should there be any hesitation? Because it's like you're going to an authority that is supposed to be unbiased, that is supposed to be above any reproach, and they've admitted they're lying.
I don't think there should be any reluctance. The reality is that there's a great deal of reluctance, certainly in this state, to hold physicians accountable. Physicians, and by and large, understand that most of the doctors, many people ask me about my own relationship with the medical community. My relationship with the medical community generally is very positive. Yes, there are some doctors that I have filed claims against repeatedly that don't like me at all, and that's perfectly okay with me. But there are many physicians who recognize that there is a real need for plaintiff lawyers who emphasize medical malpractice in order to help keep their profession policed, because they don't do a good job of that themselves. Now, our licensing board here, the Louisiana Board of Medical Examiners, for many years was virtually impotent. It really did little or nothing to address substandard care. In the recent years, there has been a change, and the investigative arm and a couple of doctors who've been hired to be investigators have been much more thorough and much more aggressive about recognizing the need to differentiate between the wonderful, dedicated, committed, competent physician and the guy that's in it to make a buck. And there is a difference.
One last question. Not only have you been a fantastic lawyer over the last 40 years representing the needs of people who have been victimized by bad doctors, but I know you've been a big advocate for trying to change the laws in the state of Louisiana to do away with the caps, for example.
That's correct.
I mean, the first step would be to do away with the cap on economic damages, because that's not addressed at all. And in case anybody doesn't realize it, the guy that's making $75,000 a year has a certain standard of living, and now they can't pay for their house. Now they lose their car, they lose their house, they're living in poverty, all because they can't get any money as a result of a doctor who wronged them, harmed them irreparably. How do you change 42 years later? How are we going to change these laws to reflect the ideal outcome for victims of medical malpractice in the state of Louisiana?
It will come when people finally recognize the injustice of where we are. Now, the first step that I have repeatedly proposed is, at the very least, shouldn't we have a cost of living index where the cap that was established 42 years ago has at least remained in conformity with the cost of living? It hasn't. So our cap today
Yeah.
is worth in $1975 about $140,000.
Okay.
So that's all it's worth. The so
by the way, I
need-
think before our interview, we talked a little bit in California in 1975. We have a cap of $250,000 for pain and suffering, non-economic damages, and on the ballot last November, there was an issue that people could have voted on to increase that to the standard of living to, I think, $1.25 million, $250 to $1.25,
Right.
which would probably be similar here.
right.
But it was defeated by the voters because they believe that greedy trial lawyers are filing frivolous lawsuits. I mean, this is ridiculous, you know.
The real problem, and we have to give credit where credit is due. The insurance industry and the American Medical Association and the pharmaceutical companies have done a wonderfully effective job of basically brainwashing the American public into believing that our system is fair and just.
Yeah, but that's why I asked this question. 42 years later, when are they going to wake up?
I don't think at this point I can share with you that this year in the legislature there was a bill to increase the cap. The author had to pull it because he had so little support for it. I have served on 2 or 3 committees appointed by the governor of the legislature over the years, and there is a tremendous resistance within the medical community and the insurance industry to any modifications in the existing law that would increase the cap, or even certainly any effort to separate or to remove economic losses from the cap.
Right.
I've shared with my own colleagues that at the present time in this state, I do not believe that modifications statutorily to the Act to address these issues are likely to occur anytime in the foreseeable future. The result is the most vulnerable people in our society, those whose lives have been inexorably changed, who are dealing with heartbreak, disfigurement, horrible quality of life, enormous bills, enormous financial loss, remain grossly undercompensated. And at a point, what the general public does not fully understand is that when that occurs, there comes a point in time when those people go on, and they have no choice but to go on the welfare rolls. So what happens is that the public, the taxpayers, end up paying for the harm caused by negligent healthcare providers.
Right.
And that's not right.
Right. And the insurance company's refusal to absorb the responsibility for the doctors that they insure.
Absolutely. And that issue alone is a real travesty, because we should have a situation where each of us is accountable for the harm we do to our fellow man. If I use this with the jury oftentimes. If I'm driving home and I'm inadvertent and I'm not paying attention and I run a stop sign and I hit a child on a bicycle and break his leg, I ought to be accountable for the harm that child has suffered. If a healthcare provider, a doctor or hospital runs a medical stop sign and harms somebody, they should be equally accountable for that harm. And that they should not, by virtue of an archaic law, be able to shift the burden of their own mistake, their own negligence, their own carelessness, their own incompetence to the taxpayers of this state. And that's what's happening, unfortunately.
I agree with you 100%. And I want to thank you so much for spending time with us, because this is a message that we want to get out as much as you.
I thank you for the opportunity to be here, as always.
Thank you, John.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.